Welcome to Mentoring with the Masters. My name is Gwen Young. I'm a shareholder at Carlton Fields in Tampa. I'm in the business litigation practice group, and I've been trying lawsuits for over 30 years. The topic that I've been asked to discuss with you today is the art of jury instructions. And I wanted to start out by talking about something that is a common mistake that trial lawyers make, and that is to wait till the last minute to prepare their jury instructions. In the ideal case, your jury instructions should be prepared at the outset of the case. They should be used as a roadmap to the case because the instructions lay out for you the things that you have to prove, whether it's the elements of your case if you're the plaintiff, or your defenses to the case if you're representing the defendant. You need to have those instructions and know those elements before you take discovery, because you want to ensure that you've developed the evidence that will enable you to prove and win your case. And if you don't know what you've got to prove, then you can't make your case. Moreover, a jury can't get it right if you don't give them the correct instructions, and therefore instructions are critical. So the first commandment of the art of jury instructions is prepare your instructions early, use them as your roadmap to the case. This has become even more important because the new standard jury instructions tell judges that they should instruct the jury at the outset of the case with the key instructions. There is some discretion with what the court is required to instruct, but those instructions are going to need to be prepared at the very beginning, and those lawyers who used to wait till the close of the case and rush around preparing instructions right before the charge conference are going to have to readjust their thinking on that. You'll want to take these instructions into account with your opening statement, with your outline of what you have to prepare, with what your witnesses are going to testify to. The instructions are a critical part of case preparation. So with that in mind, how do you prepare jury instructions? Well, the first thing that you need to recognize is that you've got to think outside the box. The standard jury instructions are just a starting point. You have the opportunity to ask the court to do non-standard jury instructions, and therefore, as you're preparing your jury instructions, you need to sit down and outline every element that you need to prove, every defense that's involved in the case, and determine whether there are special instructions that you need to request from the court. For example, if you have a construction case, you may need an instruction on the Slavin doctrine relative to construction defects. You should be thinking about, in every case, whether there are special things that need to be instructed. Once you've determined the fact that you may have special instructions that you need to draft, you need to draft those instructions. And once you get those on paper, edit them. You need to make sure that the instructions are in plain English such that the jury can understand them. And that's really the second rule of the art of jury instructions. Make sure that your instructions are in plain English, not in legalese, that they are understandable to the person who's going to be sitting on your jury. If you can do that, then you are going to be in good shape. So that's the second rule. Make your jury instructions understandable. Once you have those proposed jury instructions crafted, then you are prepared to go before the judge for the charge conference. And this is really the next critical issue for jury instructions, and that is you've got to make sure that you preserve your instructions for the record. And by preserving your instructions for the record, you start out ideally by filing a set of your jury instructions with the court. You should ensure that there is a court reporter present for the entire charge conference. If during the charge conference the judge denies one of your instructions, you need to make sure that you make it clear on the record that you're objecting to that and that you're not abandoning your jury instruction. You then need to make sure that when you're working on jury instruction, because many of you know when you get into a charge conference, people will start rewriting instructions, and you're going to be asked to agree to language in an amended instruction. And you have to make sure that you put on the record that while you're cooperating in the crafting of this instruction, you're not in any way waiving your objection to that instruction or your request that the court give the instruction that you requested in the first place. Because frankly, if you acquiesce in the revised instruction, your record is going to appear as though you agreed to that instruction and you waived your objection to the instruction. In some instances, if you can and if there's time to do it, you really ought to make sure that you have preserved at the close of the charge conference each and every objection that you have for instructions, that you have made sure that the record reflects those instructions that you requested and were not granted. For the right case, you would try to have written objections to instructions that the other side has proposed, because of course you need to remember this is a two-way street. The other side's going to be proposing non-standard instructions, and you've got to be prepared to deal with their instructions as well. One of the things that I say to people, and because I'm with a larger law firm, I have the benefit of doing this, and that is for the right case, it's very important to have an appellate lawyer involved with you early on and to really involve your appellate lawyer in the preparation of the jury instructions and perhaps being with you at a charge conference. Another thing that people often don't think about is, are there issues in your case where you disagree with what the law is on the case? You may want to actually offer an instruction as to what you think the law ought to be on a particular topic, noting that this is not the law and you understand that the court has to instruct on the current state of the law. But what you do when you do that is to preserve that argument for appeal. And in certain areas of the law, you'll find that lawyers are trying to get a particular legal issue in front of the appellate court to see if they can change the law. And one way you can do that is by proposing that as a jury instruction and preserving it as an issue on appeal. The final thing that I would say with respect to jury instructions is that once you've been through your charge conference, once the set of instructions that the court is going to give are agreed to, you need to listen as the court reads the instructions to ensure that they are actually giving the instructions that were agreed to, because it's very easy, particularly when you have non-standard jury instructions, for the court to get pages mixed up or to have something happen and they skip something. And so if you're going to have your record preserved for appeal at trial, you've got to make sure that the court's giving the right instruction, and if something goes wrong, you've got to object and you've got to make sure that it's corrected. So this is a process in which you have to stay on your toes. In summary, there are really three rules or commandments for the art of jury instructions. One is prepare them early. Two is put your non-standard instructions in understandable English. And then three, once you've prepared that set of jury instructions, ensure that you have preserved your record on appeal for those instructions, and then you're going to be in your best position for trial.